The court, Mr. Whitaker, ladies and gentlemen of the jury. We are now at the stage where at some point you will receive this case for your deliberation, and I would like to thank you, each and every one of you, for your willingness to serve, for your attention, and for your jury service. I know it can be a difficult thing, and we all, everyone I believe I can speak for in this courtroom, is very grateful. You'll recall that you are the trier of the facts. You get to sit here and determine what weight to give the evidence that you've heard. Whether that evidence is testimonial in nature or whether it's physical in nature. Now, the judge is going to instruct you at some length as to the law in this case. And you've often heard myself, Mr. Whitaker, Mr. Nishniak, and the judge using legal terms in this courtroom. You must listen very carefully to his instructions. But let me put you a little bit at ease. When all is said and done, the judge is going to send back to the jury room with you a copy of those instructions. So you'll have all those definitions that you need ready at hand so that you can refer to them if you need to. So I guess I'm saying you don't have to memorize what he's going to tell you when he does that charge to the jury. As we talked in voir dire, the burden of proof in a criminal case lies with the state of Ohio. And that burden, as you know, is for the state to prove each and every element of an offense beyond a reasonable doubt. You'll also recall that the state's burden is not beyond all doubt. It's not beyond the merest shadow of a doubt. And it's not to prove something to an absolute certainty. These aren't standards that the prosecution is required to meet. And that's because everything is subject to some possible doubt. So what we're looking for here, ladies and gentlemen, is reasonable doubt. The judge is going to define that for you as well. Now, I'm going to have an opportunity to speak to you after Mr. Whitaker addresses you. So the state, on closing argument, gets to start, and we get to finish. And there's a reason for that. And the reason is very simple. It's because the state has that burden of proof beyond a reasonable doubt. And that's why we get to address you more than once. Complicity is something the judge is going to instruct you on. And it's probably one of the more important things in this particular trial. And it's certainly going to be one of the first things that the judge talks to you in terms of the jury instructions. You'll recall that we talked a little bit about complicity on opening. And you'll also recall that when someone participates as a group in a criminal enterprise, whether they're the principal actor or whether they're someone who is complicit, and that is aiding and abetting one or more people to commit a criminal offense, that person is just as guilty as if he committed that crime himself. If, for example, there's a bank robbery, and during the course of that robbery, there's a guy out in the car. We talked a little bit about this with regard to perhaps a Circle K, but this is a little bit different example. There's a fellow sitting out in the car, and there's a couple of gunmen in the bank, and they're holding the bank up. And in the course of that robbery, during the confusion, a little old lady gets knocked over. She lands on the marble floor in that bank, cracks her head on the floor. Ultimately gets a brain bleed, her brain swells, and as a result, she passes away. Each and everyone who participated in that bank robbery now stands to be charged with felony murder as a result of that lady dying. Even if none of those individuals laid hands on that lady. Even if people panicked and were running out and she got knocked down as a result of that crowd leaving the bank. They still stand to be charged under Ohio law with felony murder. Now, in this particular case, we know that the defendant, Jonathan Dukes here, volunteered to accompany Cortez Oliver, Darrell Dukes, and Jody Fetty to go to Richard Lowther's residence. And what I will say to you is what I said before. They all went together. They all did this together. We're looking at the four musketeers here. All for one, one for all. Some of you might remember that old English saying, in for a penny, in for a pound. And that's what we have here, ladies and gentlemen. They all knew that Richard Lowther was awake. They all knew where they were going. They knew they were going to his house to retrieve the safe. You heard the testimony that initially Jonathan Dukes here and Cortez Oliver, dressed in black, snuck up to the back of his house or took a look through the windows, saw Richard was up, lights were on, they broke it off at that point, went back to the car. When they decided to go back, everybody in that car knew Richard Lowther was awake. They knew the first plan were, look, this old guy will be sleeping, we'll sneak in here, we'll get what we need to get, we'll get out, nobody will be the wiser. They knew that wasn't going to work. Everybody in that car agreed that somehow they had to get Richard Lowther out of the way. They had to incapacitate him now because he was awake. Everyone in that car knew that someone, be it Cortez Oliver, be it Jonathan Dukes, doesn't matter, was going to take Richard Lowther out in some fashion. They knew that someone was going to physically assault Richard Lowther in that house. They all knew this was an old guy. You heard all that testimony about the old guy. The old guy. They knew he was an old individual. And everybody knew that Richard Lowther could be injured as a result of what their plans were. So, ladies and gentlemen, not Cortez Oliver, not Jody Fetty, not Darrell Dukes, and certainly not Jonathan Dukes, cared. They didn't care. Didn't matter because this home invasion would have been broken off after they saw Richard was awake, had they cared. They weren't going to stop until they got what they wanted, and that was all the money that they thought Richard had in that house. Some $50,000 or in excess of that. And for the four musketeers, they thought that was going to be easy money, because this was an old guy. Nobody else there, lives all alone. Let's talk a little bit about the elements. When you go back in that jury room, you're going to discuss and you're going to review the indictments and the elements that are contained therein. We're going to start with aggravated robbery. It's a felony of the first degree. And Jonathan here is charged that on July the 2nd of 2009. Okay? So the elements. First is Jonathan Dukes. We know that by his own admissions. We know he was there. We know how he got there. July the 2nd, 2009, you heard the date, it was repeated over and over again. Next element is in committing or attempting to commit a theft offense. Okay, what do we know? We know that they planned to go and steal from Richard Lowther. We know this from Jonathan's own statements. We know it from Darrell Dukes and Jody Fetty's testimony. And we know it from the physical evidence that was gathered up. These coins came out of Richard Lowther's house. We know all those things. So we know that a theft offense was committed in the residence, and that takes care of that particular element. And when I talk about this, I want you all to know that I'm arguing that the state has proven these elements beyond a reasonable doubt. Or in fleeing immediately after the theft offense, recklessly. What's that mean? It means that a person with heedless indifference to the consequences perversely disregards a known risk that his conduct